is rotting in jail because all the LA County judges took bribes and he caught them. That's what we know. That's what we know for sure, for fact. So, moving on. I'm never going to get done with this if I don't keep focused on my affidavit. In addition, there seems to be a secret agreement between Gonzalez and Galipo that any reference to Aaron Maropulos, that was the third kid that got a gunshot to the head, who was murdered by shot to the head in his car at a gas station, and the fact that Aaron had told friends and family that he, Aaron, had seen Langford set the fire, would not be made in this trial that I witnessed. It should have been stated. Gonzalez used Federal Rule 50 to argue no witness said they actually saw Langford set the fire. But the dead Maropulos kid, Aaron, had told people that. And apparently there was an audio tape of that, but that was not going to be brought in to evidence. This was the worst run case, and Dale Galipo was Attorney of the Year. Now, do you know why they make people Attorney of the Year? Because they play the game so the system wins and the victims lose, in my humble opinion, my First Amendment right to speak my opinion. Shame on you, Federal Judge Terry J. Hatter, Jr. I am not impressed with your great big portrait of yourself in your federal courtroom. It was more like Satan's Hall of Justice, or Satan's Hall of Injustice. I personally investigated the gas station. I sought witnesses and have tracked this case for years. I have video I've never shown you. I've been waiting for this trial. Allegedly, the surveillance tape from the gas station was never asked for by Galipo. Really? In discovery. Really? Specifically, Aaron's testimony would have prevented this case ending this way, as Gonzalez made the oral motion to dismiss because Galipo failed to present one witness, like Aaron Maropulos, to state defendant had set the fire. Defendant, Sheriff Deputy Steve Langford, had set the fire. Nor did Mr. Galipo argue that the tapes to that effect had been heard. He didn't even make that argument. This was the weakest argument by an attorney helping victims' family I've ever heard. I've sat through hundreds of cases. Attorney Galipo did weakly argue circumstantial evidence is often used to convict, but he did it with as little conviction or zeal as I have ever seen in a courtroom, as if to be just mouthing the right words with no conviction or passion for the 8-person jury to hear. So the court official record would get it down and he could avoid a malpractice lawsuit. Because, oh, it's on the record, I did argue circumstantial evidence can be used. I did make that argument, so you can't convict me of malpractice. But I'd like to interview those jurors, those 8 jurors, and see what they would say. How did they take his almost apologizing for bringing the lawsuit? And, oh, yeah, circumstantial evidence can be used, Your Honor. He did it in front of the jury so as perhaps would sense a lack of passion, outrage, and perhaps not believe Galipo's argument. In the face of what this family has suffered, this is an outrage by Galipo. The court system, in my view, after years of watching and videotaping court proceedings, the lack of Sheriff's Department to identify and prosecute Aaron's murderer when they had the videotape of it for years, yes, I got it, for years is highly suspicious. The total failure of Galipo to obtain the tape in discovery in the other case of Aaron is highly suspicious in my opinion. John DeHaan appeared to be, from his stated resume, a lifelong government employee gone independent to be a hitman expert for the Sheriff's Department, and the Maropulos fire expert, Allred, seemed to be a man frustrated with government over cover-ups like the fire chief he quit working for, who was always the first on the scene of a fire. Between the two of them, DeHaan knew nothing firsthand, but Maropulos fire expert did a first-hand investigation and seemed far more reliable. The fire department had they testified, would have had to admit they all knew they had comparative negligence liability at the time of the fire, February 20th, 2002. So all their fire reports and fire investigations is obviously suspect. They should not have listened to Deputy Langford when they arrived 18 seconds after a neighbor called in the fire. And Langford was already standing there, making no effort to rescue anyone. This case has been mishandled by the police, the fire investigators, and I can only conclude it is intentional to protect the guilty. I have seen many cases in many states, but this case is the worst justice system-wide failure and brings total disgrace to Judge Terry J. Hatter, Jr., the Los Angeles and California Bar Association, the Los Angeles Sheriff's Department, and the Sheriff Baca himself, who should lose the next election. Justice has been delayed and denied for 8 years. 3 people are dead, and the sheriffs have long closed the case with no one arrested for the arson murder of Rachel and Joey, attempted killing of the 3-year-old Jacob, and the point-blank gun murder of Aaron Maropulos. Court denied me media request to videotape, and the court bailiffs ordered me to not take written notes in blatant First Amendment violations. But if I forgot any significant fact to this case, that is the reason. If I misstated a fact that I saw, that is the reason. They wouldn't let me videotape it. It should have been videotaped. You should all see this disgusting thing that happened in Judge Hatter's courtroom. Liability also rests with the prior attorney firm of Maropulos family had retained, in my view, but that is not something I witnessed firsthand. In my view, this case with 3 murder victims, all in one family, from 2 separate incidents, with no one on criminal trial, when a surveillance tape of Aaron Maropulos existed for 8 years ago, indicates that the Los Angeles sheriffs can no longer be trusted. The public trust in the Los Angeles sheriffs is hereby, in this Maropulos case, unwarranted. This was an intentional non-investigation. In short, a cover-up, in my opinion, based on what I witnessed in the 2 days of trial, August 3rd, August 4th, 2010. Judge Terry J. Hatter, Jr., knowing about the dismissal of the stronger case against the government on Aaron Maropulos, should have let the jury decide this one. And in the interest of justice and the public's right to know, granted my media request or hired another to videotape the entire proceedings. And it does appear Judge Hatter, Jr. made himself a potential co-conspirator in the making sure no county sheriffs, no fire department personnel will ever be indicted nor convicted of the blatant murder of Rachel Joseph by fire and Aaron Maropulos by gunshot at point-blank range in view of 4 other people who were not called to testify. Nor will any civil wrong death suit ever succeed. Justice delayed is justice denied. This case proves that axiom again. I make the above statement based on my view of the trial, my knowledge of the circumstances without prejudice for or against anyone, but based on the observations. Signed the 10th day of August and witness. That's my affidavit. After this, I don't know. County grand juries, militia arresting officials that break their oath of office. I hope you pay attention and will be saying, catch us next week.